In relation to Kylie's observation, the common law is different from the ADJR requirements. That's certainly true, and I hope that that point is made in the notes. And it is important for this course to appreciate the different way that the ADJR works to the common law, because you may find that the exam, for example, asks you to give some explanation about, in a practical way, about how that distinction works. So certainly, and that's not just true of the no evidence ground, that's true of the ADJR requirements, generally speaking. And I suppose, Kylie, your observation stems from an observation I made earlier in the semester, which is that the ADJR Act sort of codifies or reflects the common law grounds. And that is in a general way it does that. So, for example, it wasn't through, just to deal with this week's subject, it wasn't through any remarkable inspiration of Parliament or the researchers and policymakers who worked for the relevant minister at the time that the ADJR Act was created that they came up with this no evidence ground. It is quite obviously a reflection of what was the situation at common law, or the fact that that sort of a ground existed at common law. But what often happens, and this process of sort of trying to codify the statute, the common law, is a pattern of legislating which is not unique to administrative law. You'll see this throughout your studies. A recent example being the Personal Property Securities Act, which you'll deal with hopefully in commercial law. You might even deal with it in corporations law if it goes into corporate insolvency. There may be an insolvency course, I'm not quite sure. But you'll see, for example, there that what the Commonwealth Legislature tried to do was to codify to some extent a range of different ways that you can secure your interest in personal property. But in doing so, as is the case with administrative law, they tend to tinker or create ways that the relevant legislation works. And so that is true of the no evidence ground, and in particular it has a more confined application. But always remember, both as a matter of practice and also more immediately for the purposes of the exam, that it sits alongside the common law. So to the extent that the ADJR Act limits the availability of the no evidence ground, always remember that if something turns on the limited application of the ADJR Act, that you've still got resort to the common law should you need it, unless, of course, the common law is ousted by a particular act, but you tend not to see that a great deal. And, of course, as you, I hope, will remember from your introductory subjects, you only oust the common law by express reference. Okay, Kylie, that sounds like the wind-up. Sounds like I've answered your question. Gordon can see no difference in Bond and Cara, so we're skipping to the problem questions. Anyone else who just joined us, Paul, Jimmy, or Robin, or Ray, we started the lecture. I just asked whether anybody had any questions arising from the materials or generally. As per usual, there's a request to go to the problem questions. But before we do that, do any of those of you who joined just after 6 have any particular questions you'd like to raise before we go into the problem questions?
I've got one, Brett.
Yeah, go ahead.
Where it says that basically it said that there is no error of law simply in making a wrong finding of fact. Can you clarify the wrong finding of fact a bit more? Because I'm getting a little confused as to, you know, a wrong finding of fact and no error of law, like if something's unreasonable, but then that it's saying that, and that was to do with ex parte White and the district court one. I'm just getting a little confused about, it just seems conflicting to me. I'm not sure if you can help with that.
Look, what I've said, and I've just posted the podcast for this week this afternoon after I recorded it, and I deal with that a little bit. But at the outset, let me say this. Of all the weeks that you'll, hopefully the preceding weeks are starting to gel a bit and you're starting to see how judicial review is different to merits review, how administrative decision makers are allocated power and they have to act within that power, those sorts of things. This week what we're dealing with is a much more complicated subject matter, and it bamboozles some lawyers. Because what we're talking about is the way that you reason and make findings that give rise to decisions. So we're talking about mustering evidence, how you rely upon evidence to make findings of fact, how findings of fact can be peripheral, if you like, to use that word, and how sometimes they are critical findings of fact which relate directly to a legal question which is raised by a statute. And I use in the podcast the example of a refugee, for example. To find that somebody's a refugee, amongst other things, you have to find that they have a well-founded fear of persecution. And you have to find a link between that persecution and some subjective aspect of their character. So whether it's a particular religious belief or whether it's a particular political belief. And so in order to enliven the jurisdiction to protect a refugee, what a decision maker would have to do is to find, firstly, that they had a well-founded fear of persecution. Now, almost everybody that comes to Australia, and indeed any country seeking asylum, will probably say they have a fear, that they're fleeing fears. And so that sort of element is going to be enlivened pretty quickly. But in the off chance that a decision maker, for example, a member of the Refugee Review Tribunal, failed to turn their minds to whether or not a person had a fear and whether or not that fear was a well-founded fear of persecution, then they would, if they ultimately found the person to be a refugee, risk being proceeding by way of judicial review, seeking to strike down their administrative decision because they'd failed to make an appropriate finding. So you can see that this is sort of quite complex, and one of the things that if there is any particular week where you need to read the notes more than once and you need to read the textbook more than once, this is it. This is the week. Now, in respect of Ray, your question, I think the core of it was the way that no evidence works. Do you want to just give it to me? If I haven't answered it already, just perhaps based on what I've already set out, maybe ask the question again, just so I understand it clearly, if you will.
Yes, see, the whole thing's based on no evidence, and yet it's saying that there is no error of law simply in making a wrong finding of fact, and it has said that there is no error of law simply in making a wrong finding of fact, but it just doesn't seem to make sense.
Okay, so let's deal with the relationship between findings of fact and evidence first. Can anybody succinctly state for me the relationship between evidence and fact-finding? That's the beginning. I think to understand how this all works, I think the starting point is to understand the relationship between evidence and fact-finding. So let me just deal with, Murray says, evidence has strict rules developed over centuries. Fact-finding is not bound by those rules. Now, there are common law rules of evidence, which in Australia have now been codified in, well, largely in most states have been codified in the Evidence Act. You'll deal with that in a separate subject. That's certainly a true observation, and for the purposes of administrative law and for the vast majority of tribunals generally, even in some court jurisdictions such as family law, for example, the rules of evidence as we understand them do not apply, and that a decision maker is sort of permitted or has a discretion to find facts at large, which means they can sort of apply whatever process naturally appeals to them to find those facts within certain limits. So how they do that, of course, and this is I think the point that Kylie is making, and Jimmy as well, is that to find a fact, and remember that where law and in particular litigation, including administrative type litigation, differs to, for example, scientific fact-finding, is that we're looking at past events. We're not looking for abject truth. What we're looking at is mustering what documents or witnesses we have to tell us what the state of affairs was at some past time, and we do that by collecting those pieces of evidence. We assess them, we analyse them, we work out which parts are relevant, which parts are not, which parts are more reliable and which parts are not, which parts are credible and which parts are not, and then we muster that all together and we say, as a result of hearing from these three witnesses and looking at this document, I find that the car was blue, as opposed to the suggestion being made by the other party that the car was red. And it's through that process of relying on evidence that we find facts. Now, where the no evidence and the wrong fact-finding aspect come into play in administrative law is what the decisions about wrong findings of fact are saying. And this is I'll come to that in a minute. What the decisions about wrong findings of fact are saying stems from a subjective analysis of a finding. So what we say is that it is not an error of law to go to the court seeking judicial review and to say the decision maker got that particular finding wrong. You don't have an error of law. And remember that judicial review is about finding an error of law. What you're looking for is an error in the process, where, as opposed to merits review, where you're generally just seeking a new decision maker, usually hopefully a better decision maker, just to re-find the facts. Now, there are exceptions to this notion of wrong finding of fact, and it's perhaps the expression wrong, or the word wrong in the expression which adds confusion. What it's saying is that 10 people might be given the same facts or the same evidence and come to different findings of fact. The mere assertion or the mere conclusion that somebody else, in this case, for example, a judge conducting judicial review, might come to a different conclusion on fact, or a different conclusion about the fact, as opposed to what the original decision maker reached, is not an error of law. So judges, when they conduct judicial review, don't look at the facts and say, well, you know, the tribunal member got the finding about the well-founded fear of prosecution wrong because they said there was a well-founded fear, but I conclude that there was not. That's not the way it works. And so those authorities that talk about wrong findings of facts are trying to draw a distinction between what is permissible in judicial review for them and what is not. Now, having said that, where a decision maker will, there are two general exceptions to be able to, or categories of exceptions at common law, which allow you to challenge a finding of fact. The first is this notion of no evidence. So if, for example, and this is, you'll find this in the podcast, let's assume I'm a tribunal member, I've got two parties, an applicant and a respondent, and the issue, and this is a crude example, but it demonstrates the point, and I want you to think sort of more simplicity. Once you get the principles right at a simplistic level, you can move on to more complex problems. But just for the purposes of this example, one party says a car involved was blue, the other party involved says the car was red. Now, if I, as the tribunal member, muster all the evidence, listen to the witnesses and review the documents, and I come to a conclusion that the car was blue, that's not the sort of thing that will be revisited in a forum of judicial review. The judge is not going to look at that and say, well, I would have actually found the car was red, and so, you know, I accept that you've got a basis to argue judicial review. They're going to say, well, you know, the process of fact-finding is in the discretion of the tribunal member. However, let's, using that same example, assume that I'm the tribunal member. I hear from 3 witnesses. All of the witnesses say the car is blue. I receive a document which says not sure whether, it doesn't record, for example, what the colour is, whether it's a blue or a red car. And then I find, as a matter of fact, that the car was red. What I've done there is I've found a fact for which there is no evidence supporting it. All of the evidence in the case was that the car was blue. And so by finding that the car was red, I have erred at law because I've made a finding which has no evidence to support it. Is everyone with me so far? Anybody not with me so far? Okay. Now, next week, what we will... okay, good. Next week, we deal with Wensbury unreasonableness. Now, I'm not going to go into detail on Wensbury unreasonableness tonight, but I do want you to be aware that I said there are 2 sort of general categories in which fact-finding might cross the threshold of becoming an error of law. I've dealt with the first one. That is no evidence. So if I find the car is red, even though there was no evidence that it was blue, and in fact in my example all the evidence was that it was blue, I found completely contrary to the evidence, you've got an error of law. That's the sort of case in which you will be able to raise a judicial review grounds and be able and ask the court to set aside the administrative decision maker's decision. The other, and I said there were 2, the other is Wensbury unreasonableness, and this is a very unique ground of judicial review in the sense that it gets very close to being merits review, but it's not merits review. Wensbury unreasonableness is all about a decision maker who reaches a decision which is manifestly unreasonable, or to use the expression often quoted from the actual case from which Wensbury unreasonableness gets its name, a decision which is so unreasonable that no reasonable decision maker could have reached it. So that's where you get to a situation where you might start to be able to get close to judicial review. And to use our crude example, let's assume for a minute that we're back to the dispute where there's one party says blue car, one party says red car. Let's say I've got 3 witnesses saying it's a blue car, all of whom were standing next to it, and I've got a document from the manufacturer saying that the engine number and model number and registration plate number was all for a blue car, and I've got a single witness saying it's a red car. But the witness who said it was a red car concedes in their evidence that the sun was in their eyes and they only got to look at it for 2 seconds. Now, ordinarily, it would still be open to the decision maker to say, well, it was a red car. I'm satisfied it was a red car. I heard from that witness. I believe them. But that sort of factual scenario is where you would probably be able to put those facts before a judge on judicial review and say, well, here's the situation. You've got 3 witnesses who are all standing next to the car who say it's blue. You've got a manufacturer's document which says it was blue, and you've got a single witness who only got to look at it for a second, who had the sun in their eyes, who said it's red, and the decision maker has, for whatever reason, accepted that the car was red. That's when you start, and you can see there that starts to blur the lines with merits review, but that's the sort of example where you start to be able to get into judicial review arguing Wednesbury unreasonableness. So they're the 2 sorts of categories. Now what we're looking at this week, of course, is that former category of no evidence. Well, we're not just looking at that, but that's the focus in terms of a common law ground as opposed to the Wednesbury unreasonableness. Have I lost anybody? Don't be shy if I have, because this is a complex subject matter. Okay, Ray says, do they often work together? Look, they do. Well, you often find them argued in the same cases, and the vast majority of them are refugee cases, and I think I indicated to you all at the outset of the semester that my contemporary experience in administrative law, well, it's a bit of a mixed bag. Some of it's commercial in nature, licensing sort of work, and I do a bit of pro bono work when offshore asylum seekers weren't able to access the migration scheme, doing judicial review in a refugee context. And quite often, if there was a basis for me to say, look, I think you could go to the federal court seeking judicial review, it was factually related, and there was often a basis for us to assert no evidence and also Wednesbury unreasonableness. Now, that was tricky because one of the things you'll see as you get through the materials in relation to this notion of law, fact and evidence are that there are limitations on what there need to be evidence about. For example, some refugee tribunal members, for example, and not just refugee tribunal members, home building type cases and the full gamut of tribunal members who sit as administrative decision makers bring to that role a degree of experience and expertise in the particular subject matter. So for example, in the refugee area, there's a whole lot of material which is not always on the record that you need to be aware about. For example, international disputes and forced migration patterns. So, for example, you can understand for example, to be able to deal with the refugee type work, you need to have a basic appreciation of the situation as it has been in Sri Lanka for some time. You need to have an appreciation for what's going on in the Middle East and where people are actually being forced out of their natural geographical dwelling space for reasons which might enliven the protection that we're supposed to give refugees as a signatory to the Refugee Convention. And so having tribunal members who bring some background or an understanding of that to the decision-making process is cost-effective and perhaps also just generally more efficient. And when those sorts of persons bring some degree of that background knowledge to the evaluation process or the decision-making process, that is sometimes not reviewable. So sometimes, for example, if a decision maker says, well, based on, even though there's no evidence in the documents, I'm aware that the fighting in northern Sri Lanka ended on 27th of March 2012, and so this person not having left until the 27th of March 2014 doesn't seem to me to have any link to whether or not they've got a basis to allege a fear of persecution. Now, whilst the decision maker would have to put that to the applicant in order to comply with what, thinking back from previous weeks, what's the principle that would require a decision maker to put that knowledge they already have to the party? Yeah, natural justice, fair hearing, good, excellent. So if they didn't put that to the applicant and say, you know, I understand the fighting finished in 2012, you didn't leave till 2014, you might have a grounds of review based on failure to afford natural justice and more specifically the fair hearing rule. But you wouldn't necessarily have a basis to assert the no evidence ground, even though on the materials, on the documentary materials which the decision maker is relying, there may not be anything that clearly indicates that fighting stopped on March 2012 because for whatever reason, be it the minister's representatives or the applicant's representatives, they just didn't think to put that before the tribunal member. So there are some exceptions to this, to the way that the no evidence rule works, and if that is the case, then sometimes the fallback is that you go to Wednesbury unreasonableness, and as you'll hear next week, there are related grounds, and this area of law is still in a state of development, such as serious illogicality or irrationality, which work sort of closely with Wednesbury unreasonableness, but on the current state of authorities are almost may well be standalone grounds. So to argue, I'll just finish up this point so that I don't go on, don't make it too complicated. Just to answer your question, Ray, do they often work together? Often they are argued or they are pleaded together. Whether they actually work together will turn ultimately on the way that the argument or the submissions made for the respective parties unfold. So there's a degree of contradiction in there, obviously. On the one hand, you can't say there's no evidence supporting this particular fact, but then on the other side say, well, it was Wednesbury unreasonableness because you couldn't rely on that particular evidence, for example. So I think I won't go into that in any greater depth because I think probably I'm at risk of overcomplicating it for you, and this is complex enough if you're just dealing with basic principles. But are you satisfied, Ray, that I've answered your question? Okay. Anyone else got a question other than the problem questions? So Gordon says, so it is the difference between no evidence and wrong finding of fact from the available evidence. Sort of, but not quite. The wrong finding of fact is a confusing expression because it's an expression which is used usually by courts who are being asked to apply the tools available in a judicial review forum as a sort of backdoor attempt at merits review. And the expression wrong finding of fact is almost a bit tongue-in-cheek from the court saying there's not such a thing as a wrong finding of fact. A fact finder is entitled to make what findings appear to be most appealing, if I can use that word, to them at the time they've asked to hear the particular case in front of them. And unless there is no evidence to support one of the findings of fact, or unless the finding of fact that they did make was so extraordinarily inconsistent with what was before the court that it was unreasonable, then you won't have, well, I think that's fair, yeah. Gordon adds within the bounds of reasonableness. I would say if you added that, probably that would be a fair assessment of the state of play. But think of it as two separate branches. This week what we're looking at is the limitations on fact-finding and the extent to which you can review fact-finding. And then once you've got those in your head, then next week we move to the second carve-out, which deals more with reasonableness. This week what we're dealing with is no evidence. And you've got the common law position on no evidence, and then you've got the tools available to you in the ADJR Act, which are different and somewhat limited, and you need to understand how they work together and when you might need one or the other. That's really the focus of this week. Anyone else before we move on to the problem questions? Okay, great. I'm pleased to hear that, Kylie. I hope it's clearer for everybody at present. Okay, well, do you want to move on to problem 25? So if everybody's read it, the question is essentially, are the decisions of Curra Queensland Mining versus Daniel inconsistent with what the Chief Justice said in Australian Broadcasting Tribunal and Bond? And hopefully you've all read, if not the full case, because it's not a small case, but certainly if hopefully you've got a case book which contains the relevant excerpts. I know that Craig and Macmillan has certain excerpts, and you just need to be familiar with obviously the facts. And Bond, for example, is a good example where sometimes you'll find multiple aspects or grounds of judicial review being considered by a court. The short answer is, and who let the cat out of the bag? Who answered this a bit earlier? I think it was Gordon or Anthony. The short answer is that the statements are not inconsistent. It might look to some extent like they're inconsistent, but what the Chief Justice of the Federal Court, if memory serves, that's in the question, Chief Justice of the Federal Court and the Chief Justice of the High Court were saying was that a decision, let me go back a step. What the Chief Justice of the Federal Court, Chief Justice Black, was saying was that a decision based on an unimportant fact would vitiate a decision because the unimportant fact might still have been and probably would still be critical to the decision. And what His Honour was trying to say was that when you are engaged in fact-finding, each of the steps, it's not as simple. The example I gave before about the blue car and the red car I described as crude, because fact-finding is never that simple. The question of whether or not the car was blue or red, you can imagine, might only be relevant to how you might evaluate the credibility of a witness who's given evidence. It might be relevant only to how you find a more significant fact. So, for example, using the refugee example, whether or not someone has a fear, they might say they've got a fear, and ordinarily they would always say they've got a fear, otherwise their case is going to get thrown out fairly quickly and simply. But they might have expressed to another person claiming asylum that they weren't really in fear because they hadn't come from Sri Lanka, that rather they had been living in Malaysia, but they couldn't find work, so they were going to claim they came from Sri Lanka. And so part of the fact-finding process then becomes, well, do I believe the applicant who is saying they came from Sri Lanka, or do I believe this other person who might have a motive to lie about whether or not this person, the applicant, told them they were actually from Malaysia, because the person who claims the applicant said they were from somewhere else believes that by damaging the applicant's case, there might be a spot. That might be more likely that they themselves have a spot. So each of those sorts of steps in the fact-finding process can be relevant to another step. And what the Chief Justice was saying, the Chief Justice of the Federal Court was saying in the Queensland mining case, was that what might appear to be an unimportant fact might not be in reality unimportant, because it would still be critical to the decision in the sort of way I've just given you an example of. And you need to go into the case to have a look at more detail exactly how the facts were found, and there is a reasonably good analysis of that in Craig and Macmillan, so have a look at it. And so what I think it's fair to say is that the Chief Justice in the later case, that is the federal court case, was saying was not inconsistent. It just might appear on its face to have been a bit inconsistent, because what Chief Justice Mason had said in Bond was talking about proof of the non-existence of a fact critical to making the decision. So the High Court was going that step behind the fact to have a look at questions of proof, and was using the expression non-existence of a fact critical to the decision in the same way that I'm trying to explain using the refugee case, which is think to your everyday lives. You don't often answer a question which is in your head about what has happened or what hasn't happened, whether it be with your kids or your colleagues or your friends, by taking at face value one piece of evidence. What you tend to do is you analyse in your head by drawing on other pieces of evidence that you know exist. And the reason you do that is because drawing on other pieces of evidence and other known facts helps you decide what the critical fact is that you're evaluating in your head. But if you get that process of evaluating other related facts or intermediate facts wrong, then that will have an impact on the ultimate fact that you're applying. And I think probably the best way to think this through in a practical context is to look at it that way, is to just sort of sit down in a sort of almost meditation environment, just think about how you resolve in your own head things that you're told in everyday life, and how you draw on other facts to evaluate it, so that you appreciate exactly how that works. Just 1 second, everybody, please. Sorry about that. So what I would do, Kylie talks about links in the chain, and that's an expression which is taken from circumstantial evidence, usually in criminal cases. But it is a useful comparison to look at. Links in the chain is a bit different in the sense that what links in the chain is directed at is facts which are interrelated. So you can't find fact 5 unless fact 4 is true, and you can't find fact 4 unless fact 3 is true, and you can't find fact 3 unless fact 2 is true, and you can't find fact 2 unless fact 1 is true. And so what links in the chain are meant to, the expression links in the chain are directed to is a sequence of facts, each of which has to be right in order to get to the ultimate conclusion. And that is to be compared with the expression, hopefully you've heard, certainly those of you who have done criminal law I hope will have heard, threads in the rope. And so links in the chain, if one link in the chain is broken, the chain falls away. You have a non-effective device. Threads in the rope is different in the sense that you might ultimately find fact 5 based on 12 different related facts, and it doesn't matter whether or not one of those facts is wrong if the other 11 are still correct, because you've got threads. So don't get too caught up in that aspect of links in the chain, but I think the most useful way for you guys to think about this in preparation for an exam and or legal practice is just to think practically about how you resolve in your own mind decisions which are akin to administrative decisions about things that have gone on, and the way that you undertake that process by thinking about facts which are peripheral or appear to be peripheral, but which if you get wrong might ultimately bring it undone. And let me use just a very crude example for you about what I'm talking about. Let's assume that for those of you who have children, that someone comes home late after curfew and they tell you a story that the bus was late and so they couldn't get home on time. And you accept that on face value, and then you hear from a friend of a friend the next day that the kids were seen out at the park, and then they were seen getting into a car and that they got dropped off at home. And you conclude, based on that further information, that your child has told you a lie. Now, concluding that they've lied is of course dependent on A, you accepting that what the friend of a friend has told you is correct, B, that the friend of a friend either saw it directly themselves or heard it from somebody else who heard it and was reliable, that the person who saw your particular child get into the car to come home actually had correctly identified your child and hadn't mistaken them with somebody else. And so each of those different stages of fact-finding are critical ultimately to your conclusion that you've been told a lie about why the kids weren't home after curfew. And a breakdown in one or some of those other facts can ultimately bring your ultimate conclusion, that is that you were told a lie, undone if, for example, they had confused your son with somebody else's son, or the person who you got the information from hadn't seen it themselves and were assuming it based on some other piece of information they got, or the person who told you was trying to cause trouble. So you can see how there are these other peripheral facts which weigh into the ultimate equation, which might be described as not critical to the ultimate question of whether or not a lie was told, but when you go into it with a greater depth can actually determine the way that the ultimate decision is reached, they turn out to actually be more important than not. And that's the sort of issue that the distinction in Bond and Daniel is trying to enliven in your mind. And it's a critical thinking process. It's the sort of thing that you don't get straight away. I have learnt it over years and years and years of practice at doing this, and putting it into practice through arguing cases. It's not the sort of thing that necessarily becomes obvious to you the first time that you try to grapple with these sorts of concepts. Has that example been helpful to you guys? Okay. Any questions arising from it all, or do you want to move on to problem 26? Okay, let's move on to 26. I want to put a caveat on problem 26 by saying this. It is probably more akin to an employment law problem in the sense that it deals with somebody being dismissed from their employment. All right, let me just make sure I've memory served if I've got the right problem. Actually, I'm not sure that they've been dismissed, but in any event, there's a finding made against them that they've been engaged in sexual harassment. That's the sort of thing that enlivens employment issues, and is the sort of case that would probably is more industrial in a context. But what it highlights is the extent to which the no evidence ground has limitations. So it's kind of like that. It's kind of like the example I used about the blue car and the red car, in that what you've got is you've got two people, each giving different different accounts of an event. On the one hand, you've got the complainant who says this thing happened, and that's the extent of the evidence that the event did happen. On the other hand, you've got a man saying it didn't happen, and that person has a long history of good conduct, completely inconsistent, if you like, with what the first person is saying happened. And then, so that's sort of almost two pieces of evidence you've got there. You've got one, his denial, and two, a demonstrated history of good work, which is evidence in itself. It's sort of like the good character type evidence that you might use in a criminal case. And then, in addition, you've got a number of other witnesses, none of whom actually see what's going on, but are in close proximity, who don't hear anything consistent with what the first person is alleging. So you've got, one would say, a fairly strong body of evidence against the complaint. A denial by somebody who's of good history, a good character, so that lends weight to the denial. A history of not being engaged in that conduct, which, applying the rules of good character just for a minute, good character works in two ways. It goes firstly to the inherent improbability of somebody engaging in conduct, and B, it goes to their credibility when they say they weren't engaged in the conduct. So you've got the person denying, you've got the inference that should be drawn that they're a person of good character, so they're someone who can be believed, and you've got a pattern of behaviour which is inconsistent with what is alleged, and you've got a whole lot of witnesses whose evidence ultimately comes down on the side of the denial, but you've got a single person saying it happened, and a decision maker who reaches the conclusion that it did happen. So I imagine if you were Cornelius, it is a dismissal case, he was fired. So you would this would end up in the Fair Work Commission, and this is sort of the work I do for a living, paid work rather than pro bono work. I suspect that there'd be great difficulties for the employer trying to have this sort of decision upheld. That's a fairly strong case for the applicant, and in the Fair Work Commission, the case is sort of decided afresh. That's why I'm saying it's more of an employment case than an administrative law case. But insofar as you might challenge the administrative decision maker, that is presumably Mr. James' supervisor, or whoever it is who investigates it, the panel, you would be saying, if you were Mr. James, that decision is unreasonable, illogical, and it is against the weight of the evidence. Now, we'll deal more with, Peter asked about Wednesbury unreasonableness, we'll deal more with Wednesbury unreasonableness next week, and for those of you who, sorry, not next week, in the next session, there's no tutorial next week, but if you were challenging this, you'd be saying, you know, it's illogical, it's against the weight of the evidence, it's irrational, etc. But this week we're just dealing with the no evidence ground, and so the point that problem 26 is trying to convey is that, albeit that it seems unfair and almost absurd to conclude that it actually happened given the state of the evidence, the fact that there is some evidence, that is, there is the complaint by Mr. James' subordinate, it was open to the decision maker to reach that conclusion, and you could not challenge it on the no evidence ground. Does everybody understand the point I've made there? So it's only if there was a total absence of evidence that you would have the sort of factual error that would be, or the factual problem that would give rise to a legal error. I'll just go through it for Ray. Let's not worry about whether we could challenge it on the basis of unreasonableness, Gordon, because we'll deal with that next week. Unreasonableness, that's part of the Wensbury aspect. That is next week's subject. What we're dealing with this week is just the no evidence ground and whether or not an absence of evidence gives rise to an error of law. But for the purposes of this week, the relevant question is whether or not the panel's decision could be the subject of a judicial review proceeding on the ground that there was an error in the in the factual finding process. Assuming that we don't have Wensbury unreasonableness available, the only other ground we would have to challenge a fact finding would be an absence of evidence, and in this case, albeit that the evidence is not strong and that the evidence supporting the contrary conclusion is much better, we would not be able to seek review, judicial review, asserting an error of law in the fact-finding process because there is some evidence supporting the conclusion that sexual harassment occurred, and that is the evidence from Jill Lockworth, the subordinate. Does everybody understand how the fact that there is some evidence allows the fact finder to reach that conclusion, regardless of whether or not it's a good conclusion? And if that were the scenario, you could not raise no evidence ground as the error or the grounds supporting an application for judicial review, because albeit it is tenuous, perhaps inherently weak, there is some evidence, and that's the point that problem 26 seeks to establish in your minds. Does that make it any better, Ray? Okay. I'm not sure I understand your last question there, Gordon. You might want to type that out for me again. Let me deal with your first one. Can we challenge it on the basis of unreasonableness? We'll table that question for next week. I want you to think about whether or not, after you've read the materials, not next week, there's no tutorial next week, week 9's materials, after you've read week 9's materials, I want you to have another look at problem 26 and work out in your own minds whether or not you think you could use Wensbury unreasonableness on the point, and it'll actually require you to go into Wensbury unreasonableness doctrine in some detail, because it's not going to be, it's tricky. It's not it's not one of these questions that you can read first go, having read a single decision and get right. But after you've read that material and you've got a better understanding of how Wensbury unreasonableness works, come back and have a look at problem 26 and see whether or not you think you could now raise judicial review to deal with Mr. James' problem. For those of you who are in a great panic about the injustice or the apparent injustice to Mr. James, there are forums, different forums to deal with this, and as I said, that's the Fair Work Commission. I don't think this would hold up. But just with your administrative law cap on for a minute, it is not the sort of example where you would be able to go, for example, to the federal court or the federal circuit court and say this administrative decision maker got it wrong on the basis that there was no evidence or the basis that there was an error in the fact-finding process, because the court would say, well, the decision maker has a discretion to, within the bounds of the law, to engage in the fact-finding process. Judicial review is not a forum for challenging that fact-finding process. There is some evidence which the administrative decision maker could rely upon, and that is the complaint from Jill Lockworth. And regardless of whether or not there was a whole lot of other evidence which pointed to the alternative conclusion, that is not an error of law which gives rise to judicial review. Everyone with me? Would merits review apply? If there was a merits review, Gordon asks, would merits review apply? That's of course not this week's subject. We're dealing this week with error of law based on judicial review, but within the broader context of administrative law, if there was an appeals panel, let's assume that there was a DSS investigative panel and a DSS appeals panel, presumably the purpose of the appeals panel would be to conduct a merits review, but you would have to look to the statutory arrangements in the Public Sector Ethical Standards Act, for example, which provided a mechanism akin to merits review. As Mr. James has been dismissed, he would have the benefit, subject to a number of different things which I don't need to go in tonight, to a remedy, to the what's called the unfair dismissal remedy, which would mean you could go to the Fair Work Commission, and it's not quite merits review or judicial review. It's a species of power which is sort of really different to itself and combines aspects of both. But you'll all be pleased to know that by the end of your legal study, should you wish to practice and you've taken industrial law, there would be facilities to assist Mr. James, and you would go and find yourself a competent counsel who could assist you in formulating his case, and so you don't have to be too stressed about the injustice of that. Gordon, you asked a question about what could we approach it from, or is that not the point? I'm not quite following what you're getting at there. If I haven't answered that already, do you want to have another go? Peter, your observation that there was some evidence which the decision was based on rather than no evidence is right. So you look at problem 26, okay, that's great, thanks Gordon. You look at problem 26 and you say to yourself, well, I do anyway, everyone can answer it differently, but I think if you're looking at problem 26 objectively and you're making a list of the evidence in the against column, that is against finding sexual harassment, and you in the other column you put the evidence in favour of finding the sexual harassment, you've got more of a long list in the against column than the for column, and so I see an injustice there. And the injustice, if the administrative law was the only remedy, is that, and in particular if the no evidence ground was the only remedy, is that you've got a man who's been the subject of some rather capricious fact-finding who doesn't find himself with a remedy under the administrative laws of Australia. Each to their own. All right, well that's the hour. We won't. That's the two problem questions. There's much more for you guys to read, and I have now uploaded both sessions which relate to this aspect of fact-finding in administrative law, that is the week 8 material and the week 9 material. You'll see, so far as the practical application of these principles is concerned, that there's a crossover. So we'll have more time in week 9 to recanvass some of these issues, but I think probably we should stop there just so that you can all absorb the detail that I've put in already. Ray, you asked the question, do we come back on Wednesday the 7th of January? Now, I sent out an email today. I'm actually going to be out of the country until the 8th of January, and so I'm scheduling the week 9 lecture for the Friday the 9th of January. So have a look at that email. I've also made, due to court schedules and other things, I've made some amendments to the tutorial schedule over the remainder of the course. So have a look at that. Anybody who hasn't received it, make sure you follow up. But it's sort of a Wednesday, Thursday, or a Friday. I think they are from here on in. All right, well, everybody have a lovely Christmas and a Happy New Year. Hopefully you'll have a well-earned break and have a look at the materials for the week 9 and come back, and I'll make you hopefully all masters of administrative fact-finding by the end of the week 9 material. All right, guys, Merry Christmas, Happy New Year. Thanks for being here tonight.